Hi everyone, you're watching the Virtual Amicus and I am Jay Lodha. Well, success is not final, failure is not fatal. It is the courage to continue that counts. Now, we're celebrating 365 days on our channel, and there was a dream that we had that one day we will have speakers of Sir stature who would come and do sessions on our channel. Well, we consider this as a certificate of merit, certificate of worthiness or excellence on our channel. Because joining today on the Virtual Amicus is someone who needs absolutely no introduction. He's the former Chief Justice of Honorable Rajasthan High Court, former Chief Justice of Tripura High Court, former Judge of Bombay High Court, and former Acting Chief Justice and Judge of Gujarat High Court. And today he'll be discussing a very important topic. The topic for today's session will be on art of presentation of a case in a court. And joining us today is someone who high old in high esteem. We have tremendous regard for sir. He's one of India's most respected judges. It is for me my great honor for me to introduce our speaker for today's session, is Honorable Mr. Justice Akil Kureshi, sir. So thank you so much, sir, for taking out time for doing this really very special session on our first anniversary, sir. Anything that you wish to say before we start with our segment, sir?
Yes, Judge, permit me a few minutes of sharing my few early thoughts. First of all, thank you very much for inviting me. And your satire is not lost on me. And I'm also aware that this is your anniversary program episode. You are completing probably 100 programs, right? So excellent work done, Jai. Compliments to you from me, to you and your team. Keep up the good work. Good wishes for the times to come. Your program is very relevant today because due to Corona, the virtual courts have taken over physical courts for a long time. And in the process, so many youngsters have lost the opportunity of observing the court proceedings, learning, refining their techniques, and improving their skills. So these programs are very useful. I would also very briefly touch on today's topic. When you contacted me on what we should choose as a topic, first thing that came to my mind was the advocacy itself is a very vast field, starting from litigation to non-litigation practice, from plans to delivering goods. It's so vast, impossible to cover in a short span of time. So we zeroed in on topic of presenting a case in the court. And I would, as the discussion progresses, divide this topic into 4 or 5 different compartments and briefly touch on them and then elaborate as the discussion progresses. You see, presenting a case before the court has many facets. First of all, the appearance and etiquette. Okay, a young lawyer or any lawyer for that matter must be well dressed, well groomed, must carry himself or herself with dignity, and also deal with the court and the opponents and the advocates with dignity and respect. The first impression that he creates through his appearance and the way he carries himself or herself is extremely important and a very lasting impression, one aspect. Second is presentation, preparation. Preparation of a case, even before you start presenting, would require thorough study of facts and law. On facts, you must make detailed notes on where the important documents are, at which annexure and which page number, because you cannot fumble. When a judge asks you, where is the show cause notice? You cannot say, let me find out, I'm sorry, it's not 51, it's 61. You lose your focus. You do not have opportunity of diverting your attention on such frivolous mistakes. So also on law, you must prepare yourself with proper notes. What are going to be your legal contentions? Write them down on a piece of paper. 1, 2, 3, 4, 5. Back them up with legal propositions, with judgments. Carry the judgments. So that's the part of the presentation, the preparation. Then comes ethics. Ethics is an extremely important part of a lawyer's existence and lawyer's profession. He has a duty to be fair. Fair to the court, fair to his opponents, and fair to his client. As a young lawyer, the initial phase will define you in ethical terms as a lawyer. It's a golden period, a golden opportunity, but if you lay a wrong foundation, a weak foundation, where people don't trust your word, where the courts ask you to back your contention from documents, that's a wrong signal you are sending. You must have a reputation of being a dependable, reliable, and a truthful person. And that goes a long way. Then comes the presentation and arguments. That would be the theme of today's discussion. I'll elaborate in later part. And the last would be certain higher nuances. So many techniques, so many different ideas which are not so visible and do not form part of the general discussions of presenting a case. I would try to touch on them. In the process, Jay, I don't intend to make it very theoretical. I've been a lawyer for about 20 years. One day I was a young lawyer, unsure of myself, slightly nervous when the court started asking me questions I had not anticipated. From then on to about 20 years later, I became a judge. For 18 years, I've heard lawyers, seasoned lawyers, experienced lawyers, young lawyers, lawyers who are young but very bright, young and not very bright. All sorts of lawyers I have had the occasion to deal with. And I would try to combine the experience of both sides and present what it is being a young lawyer without experience and what the court would expect from you when you come before the court. That's the initial discussion I wanted to make with you.
Very well, sir. Thank you so much for all your valuable insights, sir. If you're ready, we can start with the Q&A segment because I can't wait to start.
Please go ahead. Please go ahead.
So now, going ahead with our first question, sir. Sir, on the dais, does a lawyer need to adopt a storytelling approach where he or she, narrates all the facts inside relevant case laws, judgments, or should the approach be an aggressive one, or it should be an assertive one, to the point approach? Whatever queries are posed, questions are asked, the responses have to be query specific. Or do you think that this type of a strategy or approach totally depends on the kind of case, the kind of matter, or the judge that it is listed or taken up before?
The style of arguments, I would divide in two parts. Individually, the lawyer himself, how he develops his style. And second is depending on other factors. As you rightly pointed out, the judge concerned, your opponents, kind of case, situation, and so many other things. So first of all, when you develop a style of argument, that's going to be your own for a long time to come. You cannot or should not copy somebody's style because what suits you will not suit me. I may have a different approach. I may be better at that. You may have strong points and therefore your style could be entirely different. Within that, you must have seen as lawyers, others' arguments. Some are elaborate, some are very precise, some are assertive, some even aggressive, some are more soft. I would personally present a thought before your viewers that, you see, there is a case with you and you are arguing a case before the court. An assertive lawyer will tell the judge that these are the facts, this is the law, you better give me the order which I am asking for. That's forceful. You have no option. But the other side, which I would advocate, is more persuasive. Would it not be better that you present your facts in such a manner that it fits the law that you have prepared, and then persuade the judge to an extent where he wants to give you the order. He is willing to give you the order even before you ask for it. And that's a soft style. That's always a more pleasant style and by and large more successful style. Always remember that rare, exceptional case will come before you where only law will apply and facts will have no relevance whatsoever. It can happen sometime in the field of taxation. But by and large, when we are talking of writ jurisdiction, when we are talking of civil law, when we are talking of even criminal matters, facts predominate the law applicable. And therefore, always present your facts in a manner which the judge, it will appeal to the judge. and then showing the legal provisions and the legal position. It will ensure that the judge wants to give you that order. And that's what I would say is a good style of argument. But then this is only a general style. There are so many situations where there will be need for adaptation, there will be need for flexibility. For example, when you present a case before the judge, okay, always try to judge very early the level of readiness and preparedness of the court. And that will be in two parts, facts as well as law. There are some judges who are very good at, let's say, criminal law. Some are very good in civil side, say, for example, election or cooperative law. But if a judge who is not very well versed with cooperative laws or laws of election, and you are arguing a matter before him, you will have to go a little slow. Make no presumptions. You also must judge whether the judge has read the matters or not. Different high courts, different judges, some prefer to read matters at home and come. Some prefer to be advised on facts as well. So you must know at which level the judge is ready for your matter. And then your speed of arguments will depend on that. If the judge has read everything on facts and is also very good in the law in your field, going very slow will make him impatient. Conversely, if the judge has not read the matter and maybe the law of election is new for him, if you go very fast, you will make errors, and that's not a good idea. So that's one part. Sometimes you will encounter opponents who will try to disturb the rhythm. May get up and say something, may divert, may raise objections. As a young lawyer, always be careful not to allow your rhythm to be upset by such interventions and interruptions. All right. One more piece of advice would be, if a judge asks you a question, that question may not be in your sequence of arguments, but you cannot be rigid and say that I'll give the answer sometime later. You may be honest about it, but immediately the judge would feel that you are trying to avoid the answer. So first and foremost, on facts, when a question is put to you, upfront, give the answer. And then try to explain if the factor is negative, if it is adverse to your case, you then have enough time to explain why the impact of this factor is not so decisive. All right, but never try to delay answering the question. You may not have the intention of avoiding the answer, but the first antenna of the judge goes up that he said, I'll answer it later, means he's trying to ensure that I forget the question and later on he will not answer. Don't leave that impression. Immediately upon a question being asked, answer it upfront, even if the answer is not convenient to you. It may be inconvenient answer. It may be an answer which will be somewhat awkward for you, but give the answer and then explain the background facts why the answer is not so negative as the judge might have initially thought. One more thing, you see, every time when you go before a court, you will realize that the judge is working under enormous pressure. Yours is serial number 7, but there are 70 other lawyers waiting for their turn. It will be very easy to get pressurized by this. But as a junior, as a young lawyer, your prime focus should be to argue your case. Don't carry the burden or the pressures of time that the judge carries. Your style, therefore, should be unhurried. You cannot hurry up, because in the process, you might forget a very important fact or might forget a very important contention. Never do that. You should be unhurried but precise. Today, nobody has time for long, unwinding arguments which go on and on. So be precise. The judge will appreciate that, but always be unhurried. Hurried arguments would mean you will forget a very important argument or a contention. So these are the broad ideas I would like to share with your viewers about presenting style.
Very well, sir. Thank you so much for all the valuable insights. I'm sure it will immensely benefit all our viewers with respect to the style that needs to, a lawyer needs to adopt or equip himself with. Now, so going ahead with our next question, sir, do you think participation in of young law students in moot court competitions ultimately and subsequently helps them as young lawyers to structure their arguments properly in a court of law?
Yeah, it undoubtedly does. No doubt about that, because it simulates the real court life atmosphere. You get an opportunity to argue before a jury who is sometimes mostly very learned. The results matter a lot to the lawyers, the prospective lawyers, the young students. But we must understand that this has a limited utility. It's not the beginning and end of everything. Okay. So if you approach this moot court with a proper balance, it is very, very valuable. But if you overdo it, it can be damaging. Let me elaborate on this. So, as I said, moot court simulates a real court atmosphere and then makes you better prepared. But moot court has two elements to it. First is preparation and second is presentation. So if we forget the preparation part of it and focus only on presentation, we will be making a big mistake. Okay? Sometimes it happens that you go online, borrow from somebody who has written a brilliant article. Sometimes the students take help of senior students to prepare the cases. In the process, we are losing the most important element of moot court, that is of preparing your case yourself. Remember, it is your duty to prepare. Good preparation done yourself will be far better than much better or best preparation done by somebody else, because you will learn nothing from that. The jury in the moot court might give you high marks, but you don't benefit out of this preparation. So remember, preparation is one part. Presentation is important, but it's secondary. You think of a product, okay? You want to put some product in the market for sale. Let's say chocolates, biscuits, or ice cream. You would package it very well so that in the store, a customer is tempted to pick up your product. But the product has to be good for the customer to pick it up second time. So initial first purchase would be on the package. The repeat purchase can only come if the product is good. So moot court preparation is like product. If it is sound, if your preparations are good, if you are genuinely a good lawyer, there will be repeat customers and clients. Your presentation is good, people will say, yes, he seems good. But if you're not good as a lawyer, just presentation, smart presentation doesn't carry you further. So moot court must be approached with balance. And my last bit of advice would be, don't overdo it. It should be in small doses. It does go a long way in preparing the person. And when the young students come to the court, certain etiquettes will change. For example, in the moot courts, wherever I've gone, I don't know how they carry this impression or they are taught so. As a member of the jury, they would come and say, complete the argument set. If your lordships are satisfied with my argument, can I go to the next point? That never happens in court. And gently, I would tell the student, look, whether I'm satisfied or not, you will know when I give my judgment. If you're satisfied, you can go to the next point. See, these are a little bit of what you call gloss, little bit of element of drama which comes in moot court. As soon as you come to the court, all that must be eliminated. Okay, so adaptation to the court etiquettes is also very important. The moot court will prepare you to face the court more confidently, but you must make minor modifications and adjustments which are needed for the real court field.
Very well, sir. I hope our viewers are taking notes of this, because these are really very valuable inputs coming in on the importance of moot court competition and how important is it to do everything in moderation and not to overdo it. Now, sir, going ahead with our next question, sir, in an intra-court appeal, or a division bench appeal, as we call it and term it, how does one present the case? Is it the art of presentation of a division bench appeal or intra-court appeal similar to that of a writ court or a single bench matter?
Vastly different, but still has some elements which are parallel. Okay, to begin with, In the writ petition, I assume you are the petitioner. In writ appeal, let's say you are the appellant. In a writ petition, you are creating something. You are laying a foundation of facts leading to legal propositions and matching prayers that you have made in your petition. So it's a creation. You are creating something. In appeal, you are trying to demolish or dismantle a judgment which is against you. So vastly different approaches will come. In writ petition, much greater focus would be on facts. The law will come later or sometimes even be secondary. In appeal, there will be much greater focus on law because as a single judge, the High Court is most unlikely to have made elementary factual errors. Your focus should therefore be on pointing out crucial factual errors which have led to legal errors. In a writ petition, you will have to convince the court that the facts favor you and the law which you are presenting would merit the relief which you are asking for. In an appeal, you will have to convince the court that the learned single judge has made 1, 2, or 3 legal errors. And both approaches would be very different. Second difference which you will experience in a writ petition and while arguing a writ appeal or an LPA, whatever you call it, is that the appellate courts, the division bench, would have a lot more time and leisure to listen to your arguments. Because out of 10 matters, 10 cases that a single judge decides, only 1 or 2 go in writ appeals. So the burden of number of cases before division bench is typically lesser than in the single judges. A more experienced bench will hear your cases and they will have far more grip over the matter because they'll have more time. So your arguments can be more elaborate and more unhurried. One of the things would be to upturn a judgment of a single judge of the court. And that would be a difficult task because one judge has already applied his mind to facts and laid down the legal propositions. Your task is therefore to upset this. And in the process, one of the techniques would be to give the facts yourself instead of reading the whole judgment. Because in the judgment, the judge is going to frame his order in a manner which will support his ultimate conclusions. So the sequence of facts which the judge has narrated in the judgment will be tuned to his ultimate conclusions. And that is detrimental to you because he has already held against you. So if you rely entirely on the sequence of facts as the learned judge has done it, it's not a good idea. You should present your facts independently in a sequence which will make your case more palatable to the division bench. Okay? So these are some of the difference in techniques of presentation in appeal. Be ready with the law because the legal discussions will be far greater. Be prepared for longer arguments because the division bench will have more time, patience, and requirement to go deeper into the matter. And you are trying to upset the judgment of a single judge. Your task has therefore become that much more difficult, but not always impossible. Never start with that. Difficult, yes, but be confident. If you have made your preparations well, there is no reason why you should get a favorable result if your facts favor that.
Very well, sir. Now, sir, going ahead with our next question. Sir, what would be your piece of advice to all the young lawyers who are watching this special session on art of presentation of a case? Also, if you could share or give certain tips here to all the youngsters on how to improve the quality of arguments in a court of law.
Very, very nice question, Jeff. And this is where I'll bring in the higher nuances of presentation of a case. So far, we have discussed on things which are mostly visible. I'm just putting it into proper perspective and analyzing it. But so many of these things which I've already said are so visible, you already probably know it. Now I'll try to present a few thoughts which are not immediately visible. Okay. So first of all, whenever you are presenting your case, let's say as a petitioner, it is important to know your strong points your arguments and strengths of your case, undoubtedly. But it's far, far more important to know the weaknesses of your case and strengths of your opponent's arguments. So you must predict what the arguments of the opponents are going to be. Because it is all right if you forget an argument which is in your favor, but if you're not aware of a strong argument which your opponent can make, you'll be completely blindsided. On your feet, it will be impossible to find an answer to a question which he raises, which you have never thought of. So when you're preparing a case, always invest enough time and thought on what the other side is going to argue. That will always keep you ahead of the game. Secondly, reading is the foundation for any lawyer to excel. Reading of your case, reading of general law, and reading of outside of law. Because only when you read outside of law, your perspectives widen. See, law is all about the social sciences. So law is about psychology, law is about history, lawyers must know enough of economics, world trends, some basic sciences. When you know all these things, you keep reading, your perspective will improve. You will come across arguments which you think of, which many people cannot think. So I would strongly request all your viewers to form the habit of reading of general law, whether it is directly applicable to the cases you are dealing with or not, as well as reading of other literature like psychology, history, economics, geography, world sciences, politics, and so on. There is another very important thought I would like to plant in the mind of your viewers. You see, when a judge asks you a question, you must be very alert. Because over a period, if you put in enough effort, you can predict the trajectory of the question which a judge is asking you. Because he's asking first question, but depending on an answer, he will ask you 2, 3, or 4 more questions. And if you form the technique of predicting the trajectory, what will be the 4th question from now will be, you will be in excellent position to answer all these questions very well. Most of your viewers will be fond of the game of cricket. We have all, Indian public is cricket crazy. So when they say outstanding batsman has more time to play shots, the experts say the reason is because a player like Sachin Tendulkar or Brian Lara can predict the length of the ball slightly earlier than most other batsmen do. The moment ball is released from the bowler's hand, a player like Sachin Tendulkar or Brian Lara would know where it's going to land. And that gives them that fraction of a second more to play the shot. And when you watch them on the TV or in a replay or a slow motion, you see they have just unlimited time to play a shot. He's always in position before the ball arrives because he predicts the trajectory. He predicts the length of the ball slightly early. I've given this metaphor, this example, because if you fine-tune your senses, it is possible to predict a trajectory of the court's thinking. The judge is asking you a question, but that's not the question in his mind only. He's going to ask you 2 or 3 more questions. And if you already know the 3rd question beforehand, you'll be in a far better position to give the answer. And you can try a small trick. You are sitting in a court, not for your case. Your case is at cell number 20. Cell number 2 is going on. Follow the discussion. A question is asked. What is in the mind of the judge? Not the first question. He has 3rd, 4th, 5th question already lined up. Can you predict what the 4th question is going to be? See how far you are right, and then modulate. That will depend from judge to judge, that will depend from situation to situation, that will depend from facts to facts. But if you can form this trick, if you can form this technique, it will be very useful tool in your armory. Then I remember the style of argument of senior judge Mohit Shah versus Chief Justice of Bombay High Court. When he was a lawyer, I was lawyer. And what he would do is, after completing his own arguments, he would briefly tell the court what his opponent is going to argue. Because in a writ petition, you have your case, the respondents have already filed the reply, their stand is already there on record. So he would, after completing his contentions and submissions, briefly say, the opponents are going to say three things. There is alternative remedy, therefore do not entertain the writ petition. There are disputed questions of facts, or in law, this is our opposition. And he would meet with all these arguments beforehand. Just see what it does. It will diffuse, completely diffuse the force of the argument even before the opponent has made it. If you sit down, by making only your arguments, 3, 4, or 5 arguments which your opponent is going to make will have much greater impact. So what you need to do is, after your arguments, briefly tell the court what the other side is going to argue and what your answer is going to be. That will take away the novelty of the argument which other side is going to make. And the judge is already prepared with your explanation to the arguments of the other side. I think it's a very, very nice technique. Then, you see, if you want to really take your arguments to a next higher level, as my advocate friend Mihir Bhai once told the junior lawyers in a discussion, learn to pick up verbal and non-verbal signs from the court. When the judge says anything else, means he is running out of patience. He has heard you enough. He's asking you to stop. Anything more to say means stop now. But there are times when, after some arguments, he just leans back and sits like this. A very clear sign that he has lost interest in your argument. He is not convinced. You are stretching the argument beyond his patience. You need to do something about it. You need to either change your style, change the argument, get him back into taking interest. There are times when you will see visibly his, what would I say, impatient. Very clear sign that you are stretching your argument and making demands on his time, which is not prepared to make, which is not prepared to give. So pick up such small indications and modify your arguments accordingly. One last thing I would like to share is one style of argument of a very nice counsel in Gujarat, Kanubhai Patel. Okay, very often what will happen is that a judge will be convinced by your argument before you have completed it. Or sometimes you have 4 or 5 contentions. You have made good 2 contentions and the judge is convinced that you have a very good case. And he would say, all right, you sit down, let me hear the other side. Very clearly indicating that I want to give the order that you are asking for. I don't have to hear you anymore. I don't need to hear you anymore. Very difficult situation to deal with. Okay? Because if you say, permit me to argue more, there is a possibility the judge will be a little impatient and annoyed. That, look, I am in your favor. Why are you wasting my time? But if you sit down at that stage, there is a clear danger that after hearing the other side, the judge will change his mind. And the impact or the full force of our arguments will be lost. What Kanubhai Patel in such a situation would do is, sir, please permit me 5 minutes more. I'll wind up very soon. But he'll complete all his arguments. He complete his contention, which the judge had asked him to stop, thinking that he's convinced. Don't take that chance. Very softly, very politely, borrow some more time from the court. Don't be too long then. If judge is convinced, don't go on testing his patience. But don't give up any argument Because after hearing two arguments, the judge hears the other side, and the other side convinces that his early impression was wrong, then you will be in deep trouble. And above all, no matter what happens in the court, as a young lawyer, never lose your poise. Your balance and your poise are two strongest allies. The other side will try to upset you. The judge will sometimes, not intentionally, but will ask questions which are completely out of context. Sometimes it may be irrelevant, but you cannot be impatient. You cannot lose sight of the focus of the matter. You cannot lose your poise and balance. That's the best way to deal with such difficult situations.
Well, thank you so much there for all the valuable insights, sir. Now, sir, do you think that the litigation landscape has evolved over the years? The practice has changed, and if you can throw some light and share some experiences, because you've had a stellar career, not just as a judge, but even as a lawyer, sir. If you could throw some light, share some experiences, sir.
First of all, thank you for all your adjectives, but I don't deserve them. So I had a modest practice and a modest success as a judge. But yes, in 38 years or so, which I had time to deal with the legal field, it has changed dramatically. And all changes are not necessarily bad. Some changes are good. Some changes may not be so welcome, but they are necessary. Life is not static. The field of law cannot be stagnant. And so changes are bound to happen. For example, when I started my practice in the year 1983, the judgments I would come across of my High Court, starting from 1960 when the High Court foundation was laid to 1980s, were very in-depth judgments, very high scholarly writers, great study, long arguments, and laying down new propositions. Because they had the time, they had the opportunity. The lawyers would present cases, for example, the civil side, from All England Report to Privy Council to the Supreme Court, Bombay High Court, other high courts of Sindh and Punjab, high courts of Allahabad, high court of Awadh. Over a period, that space has shrunk. When I started practicing, the judges had lesser time. But still, there were new cases and new issues. And still, there were benches, there were division benches, and there were larger benches. The lawyers, on the civil side particularly, were putting effort to lay down the new propositions. That has, over a period, got narrower scope because enormous pressure of work, pendency, all that has changed the style of arguments. Earlier, they used to argue a writ petition in the final stage for a day and more. Who has the time now? So your arguments have to be more precise, more crisp, more to the point. The techniques have changed. The court congestion requires entirely different technique. To get a matter heard itself is sometimes an effort. To have the focus of the court's attention for 5 minutes is sometimes difficult. And all this is bound to bring in new techniques. But one of the welcome change is that the entire profession has become younger. More juniors are getting success, getting more work. The waiting period is shorter. The peak of a lawyer, for a lawyer, is probably in the 50s, early 50s. You see some outstanding senior advocates peaking in their career at the age of 50 or 55. Whereas in the earlier times, it was well over 60, 65. The lawyers would be called, the leading lawyers of the bar. So these are so many other changes have come over a period. The changes will keep happening. But as I said at the beginning, all changes are not necessarily bad. Some changes are not so welcome, but still necessary. So we'll have to live with them.
Very well, sir. Now going ahead with our next question. Sir, which phase of life did you enjoy more, sir? As a stellar lawyer or as a brilliant judge?
I would drop both the adjectives, as a lawyer and as a judge. Jay, both have their individual charms. Litigation practice has that excitement. You get only 15 minutes to argue a case before a very tough court, and your adrenaline is high for a week. You go on remembering every word that was exchanged, what you said, what the judge said, what the opponent said. Some of the most enjoyable cases have been where I have a good case, but difficult case before a very hostile court. And those experiences have been sometimes the best. You know, the law of bigamy is where a person already married enters into marriage again with another person. That's a law of bigamy, second marriage. One of the cases which I had to deal with was what happens if both are already married. So the husband is married, he marries a woman who is unmarried, offense of bigamy is made. Everybody said no difficulty. But if the husband is already married and the wife is also married, and if they enter into a ceremony of marriage, is the offense of bigamy made out? We could find a judgment of a high court which says no, because the very definition of bigamy is that the marriage is null because of the pre-existing marriage of the accused. Here it is null because of the pre-existing marriage of the other person. Very dry, very technical interpretation, but the criminal law is to be interpreted very strictly. An offense has to be read as it is defined, and you cannot elaborate, you cannot go into intention of the legislation. Why I gave this example was that I actually loved arguing this case because obviously the judge was going to be very hostile. He said, what is this? Very clear, two people are committing bigamy and you are trying to tell me that no offense is made out and you are coming for quashing of the complaint. Anyway, so this was very, very enjoyable and exciting. But having said that, as a judge, it's my overwhelming favorite for a variety of reasons. Every moment of your time is occupied by something useful, something challenging, something very important. You're dealing with human lives. You're dealing with society. You're dealing with the people whose rights are jeopardized, are threatened, and they do not have wherewithal to protect their rights. And you are coming to aid of such people. The satisfaction that I got from my 18 years of judgeship, I would put it as so high that if I did not have an opportunity or did not get a chance to be a judge, probably something would have been wanting in my life. So undoubtedly, my satisfaction, my joy of working as a judge for 18 years is unparalleled.
Very well, sir. Now going ahead with our next question. Sir, you've adorned Honorable Gujarat High Court, Honorable Bombay High Court as a judge, and subsequently Honorable Tripura High Court and Honorable Rajasthan High Court as the Chief Justice. So what is your opinion with respect to the quality of arguments that are advanced by young lawyers in all these states? Is there a difference in the style of arguments or in the presentation?
There are differences, but there are also similarities. First of all, which I found across all high courts is that when you are a new judge, either new in appointment or new in that field, civil, criminal, labor, service, whatever, or new to the high court as a transfer judge or as a chief justice, the bar starts, as I said, the open gambit is always a friendly one. The bar is always welcoming, is friendly, because the bar wants a positive, pleasant, and a friendly judge. It's only when the judge makes a mistake that the bar would change its stance. That's a one overwhelming, uniform phenomena I could see across 4 different high courts. Second similarity what I could spot was that the pattern of lawyers, their behavioral pattern, their preparedness, their style of arguments was not different from court to court, but was different from jurisdiction to jurisdiction. Say, for example, the criminal side lawyers had a similar pattern, be it in Gujarat, Bombay, Rajasthan, or Tripura. The civil side lawyers would have similar tendencies, similar style of arguments, and similar habits across the different high courts. But within that, each high court would have some litigation which is more developed. And therefore, the quality and competence in that field is likely to be higher in that high court. Say, for example, Bombay being a commercial capital of the country, the commercial litigation, the taxation, the IPR suits are far many more. Stakes are higher, discussions are more, lawyers are more prepared, and the law is more developed. Say, for example, if you have followed the trend, Delhi High Court is taking the lead in arbitration cases. Because of this capital, large number of companies have their registered offices and arbitrations take place as Delhi as a seat of arbitration. So all disputes then go to Delhi High Court. Delhi High Court also has original jurisdiction. So the appeals against arbitral awards go to Delhi High Court. So across the high courts, there are different areas which are more developed. For example, in Tripura, I could see a lot of partition suits. The land laws are very different because it was a erstwhile princely state. So all lands were owned by the king. So the settlement of laws into the subjects and landholders is vastly different from the settlement of land laws in Gujarat and Maharashtra. So these are some interesting differences I could spot in different states.
Very well, sir. And sir, do you think that the Guru Shishya Parampara or the Guru Shishya trend has already wiped out or is on the verge of wiping out? Because back in the 80s and the 90s, senior counsels, senior advocates would groom their juniors, sit with them, have healthy discussions with them, which we don't often see now. Also, to add to that, do you think technology is the new guru that has replaced senior lawyers?
In the initial portion, the line had dropped a little bit. So your question was, but I could understand what your full question is.
Sure.
Because later part, it was quite clear. I believe you want to know what the changing in trend in the relations between senior and junior has taken place. Yes, things have changed, no doubt about it. I've heard so many glorious stories of how the seniors would groom the juniors, would support them, not just in their development as a lawyer, but also in their private lives as a human being, as a person. When I was in Rajasthan, I was told there's one in Jodhpur, Murudhar Mridul, and he's a very, very well-known senior advocate of Jodhpur, had a great tradition. From his chamber came large number of lawyers who became very well-known. They become judges of Supreme Court, some of them. The Advocate General of Rajasthan would tell me that when he joined, it was like a gurukul. There were a large number of juniors who would virtually live at his house, would eat there, sometimes sleep there, but work was very, very demanding. And the senior told him that every spare moment you have to sit in the court and prepare notes on the discussion of the cases which are going on. And some juniors thought it's all right if you don't do it. But after 2 months or 3 months, the senior would say, show me your notes, what have you prepared? So that was a kind of training they would impart over a period. The time pressures have probably forced the seniors. They are unable to take so much of keen interest in the juniors' progress or their development. But I don't think everything is lost. I still see some seniors taking very keen interest. The techniques have changed as they are bound to, because the style of advocacy has changed. The requirements have changed. The demands of the time have changed. So to say that the same style should be continued for a senior to groom the new young lawyers is probably not correct. Of course, it is not the same level of involvement or interest I spot in the seniors now with the juniors. But I still see large number of seniors who take keen interest in the development of the young lawyers. And I wish and hope that this tradition continues, because it's only when good lawyers are developed, good lawyers are prepared, that the judges can deliver good judgments. Above all, always remember, Judge, that as a lawyer, you are intrinsically involved in the process of protecting the rights of the citizens. Okay? The social restructuring and re-engineering which the Constitution had envisioned, the lawyers are integral and very important part of this process. At every step of the way, you will be involved in protecting the rights of those who do not have enough wherewithal to protect themselves. And therefore, the development of good lawyers, good young lawyers into sound legal practitioners is extremely important for judges, extremely important for our legal system, and extremely important for our society as a whole.
And lastly, sir, who was your mentor in this field, if you had any?
Jay, I cannot pinpoint a single person, but many people have influenced me and played big roles in development of my career, my thinking. But for shortage of time, I would cite two people. Girish Bhai Patel was a very fine lawyer of Gujarat High Court. He joined the bar at a very late stage. He was a principal in law college, resigned at the age of 50 or 55 and joined the field of law. I attribute to him development of PIL jurisdiction in Gujarat and downtrodden centric judging, which was a trend in 1980s and 90s. Unfortunately, the focus has shifted a little bit over a period of time, but Girish Bhai Patel had laid a foundation for this, and he had a big influence on me. Second person was one Mr. Harubhai Mehta. He was also a very principled person, sharp legal brain and fiery temper. In his presence in the court, no court could heckle a junior without proper reason. He would immediately jump into the fight, whether he was involved in the case or not, and protect the junior. A very fine man. He died in an accident, tragic loss for all of us.
Well, thank you so much, sir, for all your valuable insights. There are obviously certain sessions that we just don't want them to end on the virtual amicus. Sir, we are also joined by two really very special viewers, sir. Both are your die-hard fans, some people who have tremendous respect for you, for your independence and integrity. So first, I would request Ms. Nazakat Lal to unmute herself to give her a brief introduction, and please go ahead with your question. Nazakat, can you hear us? Over to you.
Good morning, sir. I have tremendous respect for your integrity, independence, and the manner in which you've retained your integrity as well as the integrity of your office. So the two questions that I had for you were, one is that while you were a judge of the Gujarat High Court, there were certain orders that you had passed against the then Home Minister. So the question that I had is that how did you stay true to your conscience despite the political pressure? And the second question is, did you ever fear what consequences it could have for you or your family?
First of all, can I take the liberty of saying that you have a lovely name? It's a beautiful word and a beautiful meaning. And that's just what I felt I say. But Nazakat, you see, I would not focus on any particular order or matter. But you see, as a judge, we have full protection, tenure protection and condition protection. Constitutionally, the tenure of a judge is assured. It is virtually impossible to remove a judge of a high court. We have seen in the history of Indian Constitution, I do not remember a single case of successful impeachment. Even when sometimes the judges are seeming to go wrong, the Chief Justice of India have had to make efforts to persuade him to resign. One of the rarest cases was a recent case. Instead of following through with the impeachment process, a judge resigned after facing a partial impeachment process. So a judge has full protection. By constitution, his service conditions cannot be changed to his detriment after his appointment. So judge has nothing to fear. The only thing that can compromise the candor of a judge is his personal ambition. As a judge, if you eliminate your personal ambition, there is no outside force can ever make you change your mind. Once I became a judge of the High Court, my ambition freezes. If I want good assignments, good rosters, I want fast progress, I want a good High Court, I want to become a Chief Justice, I want to go to Supreme Court. These are endless temptations and they don't end ever. Once you rid yourself of all these temptations, all personal ambitions, there is nothing to fear for a High Court judge.
So I just had a follow-up question. One is not so much personal ambition, but I think we all know that it's the loss of the country and the legal fraternity that your elevation to the Supreme Court didn't happen. So it's not really personal ambition, but with your integrity and merit, I think the country would have benefited and the Supreme Court would have benefited to have you. And as far as fear goes, I mean, while I understand there are constitutional protections for judges, a lot of times I think when we take decisions, we may be willing to bear the consequences ourselves, whether they're personal or professional. But I think a question that often comes to us is that would we be okay to put our family or our loved ones at risk? You know, certain risks which are out of our control and which any government in power, again, this is not about a specific political party or government, but any government in power in any part of the world, you know, can go to any extent to retain their power. So you know, you may not fear for yourself, but you may fear for your loved ones and whether you would want to go to that extent to be true to your conscience that there could be repercussions. So, did that ever cross your mind or?
Your question was very vast. I would break it down to the small compartments. First, you said that I should have gone to Supreme Court or there is a loss or something. You see, that's your personal opinion. And I trust the system to decide what is right and what is wrong. Okay. So system has decided something for me and I'm satisfied with what the system has done. The course corrections, if needed in future, the system has to evolve. So no rancor, no disappointment, no comments on that personal element. Second aspect, I would once again say, there are no fears, no pressures. Yes, the family does carry the pressures of your important actions. Okay, so every day you're dealing with some very important matters, and not just, as you might say, politically sensitive issues, but issues of grave consequences to the society. And that puts enormous pressure on the family because the judge is cut off, the judge is aloof, he has no time for the family, sometimes responsibilities. You know, there have been that I never discuss a matter with my family members till the verdict is given, signed, sealed, and delivered. So there were times when on a day, I would have dealt with a very sensitive, newsworthy matter. My wife was working in Indian Institute of Management. In the morning, she did not have time to read the newspapers. The matter has flashed across the newspapers. She goes to the office and the colleagues ask, what was that all about? And she said, what are you talking about? So that's an insulation I would maintain because your son, your wife, your brother can make a comment which may influence you and you don't want that. So what I'm trying to tell you is that's a very responsible business and the sacrifices which the family makes to ensure that the judge remains alert, remains aloof, and remains truthful to his oaths are enormous. The general public does not even have a slightest inkling on the nature of sacrifices which a family is making. But the family is prepared for that. The family has vowed for that. And therefore, in my farewell speech, I said, whatever my success, whatever measure, whatever limited, it is because of my family and friends. And that is what it is all about. The judge is visible in the public domain. What is not visible is large number of people behind him who are making these sacrifices.
Thank you, sir.
Thank you, Ms. Nazakat Lal, for both the questions. Now we are also joined by Ms. Radha Sampath Kumar, sir. Ms. Radha, I request you now to unmute yourself, give a brief introduction about yourself, and go ahead with your questions.
Good morning, sir. Thank you for being an inspiration for all of us. I've been in your court and really admired the way you conduct yourself, and you've really been an inspiration for me. I am a chartered accountant and I work in the income tax field. My question to you is, do you think it is important for judges to strike a balance between upholding the law and being just at the same time? And my second question is, can you suggest any changes that you would like to see in the Indian judicial system?
Sorry, my second part I couldn't understand. What is the second question?
Can you suggest any changes that you would like to see in the Indian judicial system?
Right. Rather, first thing, you said uphold law and be just. You see, these two things cannot be dissociated. I don't think that one excludes the other, because law is meant to be just. So when you are upholding the law, you are necessarily acting in a just manner. Yes, once in a while, once in a rare while, a dichotomy will come where upholding the law will end up acting unjustly for somebody. But 99 out of 100 cases, or probably 999 out of 1,000 cases, law and justice are on the same side. It may seem sometimes more difficult to bring about this meeting point. Very often, as a judge, I've felt that law says something and equity says something else. But if you work hard enough, if you apply your mind enough, if you bring in innovative techniques to develop, to interpret the law, it is mostly possible to bring the two together. Stretch your interpretative techniques, mold the facts to suit the law, and by and large, a judge finds a balance where he is upholding the law while doing full justice. But once in a rare while, a situation will come where the judge will feel helpless, that there is nothing can do about it. An apparent injustice being done, because that is what the law is. And therefore, we have Article 142 with the Supreme Court to do complete justice, pass any order. And therefore, very often you have seen the Supreme Court exercises 142 to do complete justice. But that power high courts do not have. The powers high courts have is to mold the relief, to interpret the law in a manner which will do justice. But after all these efforts, if it still fails, as a judge, I would not break the law to do what I think is just. When you're talking of the second element, you see, it's a very vast issue, impossible to answer in a short span of time. Of course, our system requires some changes. Any system would require changes for improvement. But I, for one, always believe in continuity with change. You cannot uproot the system. You cannot create an upheaval or a vacuum to replace it by a new system. You can always improve or refine a system which is existing. A number of things are required to be done. Appointment of judges is a crying requirement. At all levels, we are finding it difficult. We are struggling to find judges. It's not a simple problem, possible of a simple single solution. At all levels, there are different issues, different problems, different changes needed. And as I said, time is too short to elaborate on that. But definitely, first and foremost thought, which is required to be given by all stakeholders, not just judges, not just Supreme Court judges, not just a collegium of Supreme Court, not only the High Court judges, but all lawyers, members of civil society, think tank of our society, all stakeholders need to apply their mind to solve this problem of continuous and perennial shortfall of judges in all courts. As I said, there is no single solution, one size fits all, which can be fitted. From the junior magistrate to Supreme Court, mostly we have struggled to fill up the vacancies. It is extremely important that we all put our heads together and find the reasons for this and try to address them.
Thank you, sir.
Well, thank you so much, sir, for taking out time for doing this really very special session for us. I just have one thing to say. It's an emotional moment for the entire team on the Virtual Amicus. Well, 365 days of continuous and relentless work, recording, invitation, persuasion to come on my channel, editing, then posting it on social media. But today on the 15th of May, at 11:17, I can proudly say that I can declare this little initiative as a success, not because we could record more than 105 episodes on our channel, but because well, Justice Kureshi sir did a session on our channel. I can proudly say that it's a successful venture. And initially we did speak about how we considered this on the channel as a certificate of merit for our channel. It really means a lot to me and my entire team. It was a matter of great honor. I also wish to thank Ms. Nazakat and Ms. Radha for asking really very relevant questions. So anything that you wish to say towards the end before we wrap up our special session?
Just 2 minutes, Jay.
Sure.
First of all, congratulations to your entire team for this tireless work. I wish you carry on. I'm privileged to be invited for an anniversary issue of episodes. It's a pleasure and a privilege for me. I will end with a small story from a person called Scott Jurex. Okay, and this applies to you and your team, and this applies to every young lawyer who wants to make his mark in the field of law. Scott Jurex is an outstanding ultra marathoner. Marathon is an event of 26.2 miles, a grueling event when athletes practice hard for years together to run that distance at the shortest possible time. But the human race is impatient and wanted to challenge itself for a greater endurance tests. And therefore, there are marathons and beyond marathons, what they call ultra marathons. There are races which are back-to-back 2 marathons. There are races which are 100-mile long. There are races where a person runs for 24 hours. The distance is not decided. Whoever runs furthest is a winner. And these are called ultra marathons. Scott Jurex, one of the greatest long distance runners, he has written his book. And he says that there are many people, many runners who are running with me who are far more talented than I was. But they fell by the wayside simply because he would run through the meadows, he would run through the forest, he would run on the snow, he would run through blizzards and in dry weather. And he said, my motto was simple. One single slogan: you continue, when others stop. For success in life, for your program, for any young lawyer, if you want to succeed in life, remember this one motto: you continue when others stop. Thank you so much.
Thank you, sir, for all the magical words, and really means a lot. Well, to all the viewers who are watching, you will never get an opportunity of this sort again. So, feel free to write to us with your feedbacks on how you felt, and any queries, feel free to write to us. Our email is mentioned on the channel. Thank you so much, Honorable Justice Kureshi, sir, for taking our time for doing this session. And it's goodbye for now.
So, it's been a pleasure. Thank you so much.